Hello, my name is Ciara Anderson. I'm a senior associate on the Technology and Innovation Group here at Arthur Cox. This is our second video in our bite-sized series on the EU Data Act, and we are going to talk about the data access and sharing obligations. And I am kindly joined by my colleague Fionn Henderson, who's an associate on our Tech and Innovation Group as well. Fionn, do you mind just jumping in and giving us a quick summary of what the data access and sharing obligations are?
Sure, and thanks, Ciara. So, in a nutshell, individual consumers and businesses will have a new right under the Data Act to access, request, and share data from their use of connected products and related services.
Thanks, Fionn. So I guess the first question is what's in scope? So what is a connected product under the Act?
Sure. So the Act refers to these devices as connected products, but we might more commonly refer to them as Internet of Things or IoT devices. These are essentially any product that are collecting or generating data from their use, which can then be shared either wirelessly or via physical connection. And being honest with you, it's almost more difficult nowadays to think of a product that wouldn't be considered a connected product for the purposes of the Data Act. So examples can range from mobile phones and laptops through to connected cars, smart home products, and even machinery and certain infrastructure such as turbines.
Okay, so it's quite broad and probably encompasses a lot more than we think. But you mentioned that they cover services as well?
That's correct. So they cover what's referred to as related services, which is essentially any service that is linked to a connected product, that interacts with it and affects its behavior. I'd say that almost all services related to connected products will be considered in scope, except for limited exceptions like analytics services, because these don't actually affect the product's behavior.
Okay, so I guess the question is for product manufacturers and providers of related services, and I think they're called data holders under the Act, what is it that they have to do to comply with these obligations?
Sure. So there are two ways that data holders can make available the data to users. It can either be direct or indirect, but in both cases, it has to be easy and free of charge. So first, on direct access, this would essentially be where the connected product itself allows access to the data, perhaps through an interface that allows the user to access or download or stream the data in question. And then indirect access would cover a scenario where the user requests access from the data holder, perhaps through a web portal, for example. And as between the two, it'll really be down to the data holder to decide which method to implement, and relevant considerations might be the volume of users and requests or the type of data in question.
Okay, that makes sense. And I suppose the follow-on question from a scoping perspective is what kind of data are we talking about has to be shared?
Sure. So here we're talking about product data as well as data from related services. So product data is essentially any data relating to the performance, use, or environment of the connected product. And so examples here would be whether the product is off or in standby mode, as well as certain other information readings, perhaps temperature and acceleration. And it's also important to note at this point that product data includes metadata. So that's the information underpinning that type of data, such as timestamps. And then data from related services is any data that represents user actions, inactions, or behavior. And we can come to trade secret data in a second, but it is in scope.
Okay. Is there anything then that is excluded?
Yeah, sure. So derived data will be excluded from these obligations. And this is essentially where the data holder has applied know-how or an algorithm perhaps to infer something about the user. So an example here in the case of a connected car might be where onboard sensors indicate that the user hasn't interacted with the steering wheel for a period, and internal cameras also don't register eye contact for the same period. In that case, the inferred data here would be that the driver isn't paying attention, and this would then be excluded.
Okay. That's interesting. So we might just switch to talk about briefly the B2B sharing obligations under the Act, because I think they're quite interesting, yeah.
So where requested by the user, the data holder must provide any raw but usable data, again, including metadata, to a third party. And again, the idea here is to reduce supplier lock-in and promote aftermarket services, which is ultimately part of the underlying concept of the Data Act.
Yeah, they're quite far-reaching obligations, I think, ultimately for businesses to be sharing data that they probably previously considered their own data with another business. So are there any restrictions or limitations that they can put on the use of that data under the Act?
Yes, that's right, Ciara. So there are certain restrictions under the Act on how users and third party can use this type of data. So in the first instance, a third party can only use the data pursuant to the user's instructions, and so it can't go off and use the data more broadly for its own purposes. And then secondly, users and third parties can't use the data that is being shared in order to develop a competing product. However, it's important to flag here that this restriction is limited to the development of competing products, and so it will be possible for users and third parties to develop competing related services.
That's interesting. So are there any additional restrictions? I think you mentioned trade secret data. Are there any restrictions on sharing that type of data?
Sure. So like I've mentioned, trade secret data is in scope, and the idea here is that trade secret status will still apply to that type of data, irrespective of the obligations under the Data Act. In this case, the data holder can set certain restrictions, such as contractual confidentiality obligations, as well as technical access controls on this type of data. And then if the user or the third party breaches these obligations, the data holder can suspend access to this data. However, to do so, they will need to inform the competent authority in what the European Commission are referring to as the trade secret handbrake.
Okay, that's interesting, and I think I'll just mention that I think there's a similar security restriction or security handbrake. So if the data holder can show that sharing that data would ultimately undermine the security requirements for the product, where those requirements are set out in law, they can do so, but they have to, similar to the trade secret restriction, notify the competent authority. So the restrictions seem quite narrow, and then the notification obligation is a little bit onerous. But to the extent that they do have to share data, obviously that data has value to their business. Is there any mechanism for compensation?
Sure. So the data holder can agree compensation where the user has directed access. And where this occurs, it must be based on FRAND principles, so fair, reasonable, and non-discriminatory. And it can include a markup for investment time on behalf of the data holder. And then it's just important to clarify at this point that the right of access and sharing is always free of charge.
Okay. That's helpful and interesting. I'm sure data holders will be pleased to hear that. So we might get back to our original question, which is just the practicalities. So what is it that you would recommend in terms of steps for data holders, product manufacturers, and related service providers to do to start to comply or prepare to comply with these obligations?
Sure. So at the practical level, in terms of preparation for compliance with the Data Act, the first step will be essentially a scoping exercise. So this will be where data holders take a look at their products and services and determine which fall under the scope of the Data Act. And then related to this will be considering what data falls within the obligations imposed by the Data Act. After this, they're going to want to move to a consideration of whether to implement direct or indirect access and how to do this. And in this case, a consideration of engineering and technical lead-in times in order to actually implement this will be important. Then moving on, they'll want to consider their transparency obligations and then also develop certain documentation required by the Data Act, such as data sharing contracts and technical access controls.
Okay, so decent work stream there. And I just might mention on timing, so the Data Act, most of the obligations come into force on the 12th of September 2025, and that will include the obligations to provide indirect access on requests from users and to share data. But there is a delay for the requirement to design products in a way that allows for direct access, so that's 12th of September 2026. But I wanted to thank you for your time, so I appreciate you explaining what is kind of a complex area, certainly. Thank you for joining us, and please look out for our third video in the series on the cloud switching rules. You can also get more information at arthurcox.com/dataact.